Okay, we'll call this back to order. I think, Mr. Elby, you needed to.
Yes, Mr. Chairman, thanks to the eagle eye of your outstanding court reporter, we found there is a footer, a incorrect designation in the footer on Ms. McGee's supplemental testimony, the third set of testimony. Page 2 and page 4 in the footer of the testimony says rebuttal. It should have said supplemental. So what Ms. Wheat and I discussed, or what she instructed me, suggested that should happen is that if I'm asking that the commission authorize her to correct that in the record so that there won't be any confusion down the road between rebuttal and supplemental testimony.
Thank you. Ms. Wheat is authorized to correct that in the record, so we won't be confused.
And thank you, Mr. Chairman, and thank you, Ms. Wheat.
Thank you. Okay, Mr. Elliott.
Mr. Chairman, at this point in the proceedings, I would like to ask the Commission to permit me to stipulate the direct and rebuttal testimony of Kevin O'Donnell into the record. In particular, I would ask to stipulate his direct testimony consisting of 16 pages and 1 appendix, and his surrebuttal testimony consisting of 6 pages and 1 exhibit. Would ask that it be stipulated into the record.
Okay, we'll stipulate Mr. Kevin O'Donnell's direct testimony and with 1 appendix and his surrebuttal testimony into the record. And we've got 1 exhibit
To the surrebuttal.
To the surrebuttal, KWO1. So where we put that, right? Number 8. The exhibit number 8.
Thank you, sir. Thank you.
Okay, and Mr. Stark tells me we will need verification of that testimony at a later time.
He's so informed me I should have one for you by the end of the week.
Thank you.
Thank you.
All right, Ms. Bowen, you may present your witness.
Thank you, Mr. Chairman. The South Carolina Coastal Conservation League and Southern Alliance for Clean Energy call Debbie Glick to the stand. Ms. Glick, please state your name and business address for the record.
Debbie Glick, Synapse Energy Economics, Massachusetts Ave in Cambridge, Massachusetts.
Ms. Glick, did you cause to be pre-filed in this docket direct testimony consisting of 18 pages and 4 exhibits?
I did.
And Ms. Glick, did you also cause to be pre-filed in this docket a confidential version of Exhibit DG4 or Exhibit number 4 to your testimony?
That's correct.
And did you further cause to be pre-filed in this docket rebuttal testimony consisting of 11 pages?
I did.
And do you have any changes or corrections to your pre-filed direct or rebuttal testimony?
No changes.
If the questions put to you in your testimony were asked at the hearing today, would your answers be the same?
They would, yes.
Thank you. And were the exhibits to your testimony prepared by you or under your direction?
They were, yes.
Mr. Chairman, I would move to have Ms. Glick's pre-filed direct testimony entered into the record as if given orally from the stand, and to have the exhibits attached to her pre-filed testimony identified as the next hearing exhibit.
Okay, Ms. Glick's pre-filed direct testimony will be entered into the record as given orally from the stand, and her exhibits DG 1 through 4 will be exhibit number 9.
Thank you, Mr. Chairman. And to the extent we need an additional hearing exhibit for this, I would further move to have Ms. Glick's confidential version of Exhibit DG4 entered into the record under seal.
That will be entered into the record under seal, and that'll be number 10.
Thank you, Mr. Chairman. And apologies, just to confirm, did we get both the direct testimony and the rebuttal?
Did not.
Okay.
Do the rebuttal.
Got it. Thank you, Mr. Chairman. Finally, I would move to have Ms. Glick's pre-filed surrebuttal testimony entered into the record as if given orally from the stand.
Okay, Ms. Glick's surrebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Ms. Glick, did you prepare a summary of your direct and surrebuttal testimony for today?
I did.
Thank you. Would you please give your summary to the Commission?
Sure. My direct testimony was pre-filed with the Commission in this docket on August 18th, 2018, on behalf of the South Carolina Coastal Conservation League and Southern Alliance for Clean Energy. The primary purpose of my testimony is to provide input on the Duke Energy Carolina's 2018 application of the net energy metering methodology for valuing the costs and benefits of distributed energy resources. My testimony specifically addresses two components: avoided transmission and distribution costs and environmental costs. Duke Energy Carolinas continues to assign a value of 0 to 7 of the 11 components of net energy metering valuation methodology without presenting a detailed analysis of many components, including avoided transmission and distribution capacity deferral and avoided environmental costs. In the 2014 Settlement Agreement and Commission Docket number 2014-246-E, the parties agreed that placeholder categories would be updated when the capabilities to reasonably quantify those values became available. My testimony points to categories of avoided costs that currently can be and therefore must be addressed in this docket. First, I discuss avoided transmission and distribution capacity. In Duke Energy Carolina's direct testimony, the company continues to assign avoided transmission and distribution capacity a value of 0 without providing a methodology to support this value. I outline in my direct testimony the differences between distribution and transmission system impacts from net energy metered distributed energy resources, particularly distributed rooftop solar photovoltaics. I explain the need for a detailed distribution system study to quantify the avoided distribution capacity costs. For transmission system costs that can be avoided by distributed energy resources, I describe 4 available approaches to quantify and calculate this value. I then use one of these approaches, the current value approach, and input data that's publicly available from the Federal Energy Regulatory Commission and the company's integrated resource plan. Using this method, I arrive at an avoided transmission cost value of $0.046259 per kilowatt hour for Duke Energy Carolinas as a summer peaking system and $0.005028 per kilowatt hour for a winter peaking system or dual peaking system in which winter peak is used. Because Duke Energy Carolinas says in its integrated resource plan that it now has significant winter peaks, I recommend that the Commission direct the company to adopt the avoided transmission cost value of $0.005028 per kilowatt hour. Second, my testimony discusses avoided environmental costs, focusing on coal ash disposal. I outline 3 categories of costs associated with coal ash disposal that should be accounted for in the net energy metering valuation update: variable operating and handling costs for coal ash disposal, capital costs associated with expanding or building new coal ash impoundments, and the values associated with the risk that an impoundment will leak. I utilize confidential data provided by the utility on coal ash landfill construction costs and timelines and publicly available data on coal generation to calculate the avoided capital cost associated with coal ash landfill disposal of $0.0002 per kilowatt hour. I recommend that the Commission direct the company to adopt the avoided environmental cost of $0.000002 per kilowatt hour. Now for my surrebuttal testimony. My surrebuttal testimony was filed with the Commission on August 31st, 2018. The purpose of my surrebuttal testimony is to respond to company witness Snyder's rebuttal testimony, including correcting 2 misstatements by witness Snyder regarding my direct testimony. First, when discussing the comparison between solar photovoltaics and energy efficiency, witness Snyder states that my direct testimony asserts that distributed solar generation has an identical impact to the system as demand-side energy efficiency. My testimony actually stated that the load reduction that the transmission system experiences will be identical between energy efficiency and distributed energy resources like solar photovoltaics. My testimony focused on load, not impacts broadly, and focused on the transmission system, not the entire system. In witness Snyder's critique of my avoided transmission capacity calculation, he states that I relied on the assumption that the system was summer peaking. My rebuttal testimony outlines that my calculations assess both summer and a more conservative dual or winter peaking system, and my recommendation to the Commission was to adopt the more conservative approach and value based on the company's most recent planning documents. Second, in responding to witness Snyder's testimony regarding avoided transmission and distribution capacity, I point out that his arguments about the intermittency of solar and its alignment of peak focus on the distribution system. I explain the differences in how the transmission and distribution system are impacted by the installation of distributed energy resources like rooftop solar. I reaffirm my findings that an avoided transmission capacity cost of $0.005028 per kilowatt hour and recommend that this value be adopted for the avoided transmission and distribution capacity component of the net energy metered distributed energy resource valuation update. Finally, I reiterate my concern that the coal ash disposal costs are not being fully integrated into the annual valuation updates. Company witness Snyder stated in his rebuttal testimony that the avoided capital costs associated with the construction or expansion of new coal ash landfills would be small and effectively round to zero. I point out in my rebuttal testimony that the valuation methodology approved by the Commission in 2014 does not give DEC the discretion to decide that a value is too small to warrant calculation. If a value is reasonably quantifiable, then it should be included in the annual updates, and a placeholder value of 0 should no longer be used. Witness Snyder also stated in his rebuttal testimony that certain coal ash handling costs are currently incorporated into the avoided energy component. To promote transparency for the Commission and for interveners, I recommend that the value of avoided coal ash disposal handling be separately reported from the avoided energy component and expressed as a distinct value under the avoided environmental cost component in future proceedings. The company is capable of doing this as it already separately reports avoided criteria pollutants. This concludes the summary of my testimony.
Thank you, Ms. Glick. Mr. Chairman, the witness is available for questions.
Thank you. Mr. Elliott. Mr. Nelson. Mr. Ellaby. Commissioners. Commissioner Elam.
Good afternoon. Ms. Glick, I'm going to give you the shot at what I was talking with Mr. Snyder about, real-world examples. On a transmission system, what are the kind of things that increasing solar in pockets of generation, what expenses can that cause on the transmission system?
On the solar on the transmission system only?
Yeah.
So if you increase the amount of solar on the distribution system, so on customers' houses, net metered solar, which is what we're talking about in this case, then you decrease the amount of energy and generation that needs to move from the large generators that are connected to the transmission system to flow through the transmission system and then to the distribution system. Witness Snyder was talking a lot about the large-scale commercial and utility-scale solar, which is separate completely from the net metered solar, which is what we are talking about in this docket. So the amount of solar that's on the system, the distributed solar, is not going to cause increases in the transmission system costs on this system.
Are you saying that it can reduce it, though? That's
Yes.
your testimony.
That is my testimony, yes.
As for the distribution system, is there an example you want to talk about there at how it could decrease the required investment?
Yes. So I do not make a recommendation, I'll just say clearly, in my testimony on the value for distribution system impacts, because over the entire system, it can vary. A detailed study is needed. However, as for a specific example, if you have a distribution system feeder, for example, that has a large amount of load demanded behind it, and you put solar on the the load consumers in that area. So you no longer need to bring generation in from outside that area. That's an instance where you can reduce the cost of the distribution system. And I will say that in DEC's 2018 IRP, which was just published at the end of August, they clearly state that they are in the process of developing models to understand the locational values. So I'd encourage the Commission to find out more about when this kind of locational understanding of the value of distributed solar will be available.
Okay, you say you're using numbers from, I guess, you said FERC and from their IRP. Are the numbers you're using sort of net of potential cost savings or increased cost, or do you not agree that there could be increased costs as a result of adding rooftop solar?
So the numbers that I'm using from FERC are not numbers that are saying that this is a cost. The numbers I'm using from FERC are the numbers on the amount of generation that is moving over the transmission line. So it's looking at the amount of electricity that's moving. And I'm using that as a way to understand the amount, how load has changed in the system. So transmission lines are generally built in relation to increased demand, increased load. So I'm not looking, FERC does not publish net costs increases or decreases on transmission system spending. This is numbers I'm using to do the calculations myself using the current values approach that other utilities have used.
Does it make any difference as to whether or not the distribution utility is vertically integrated or whether it's part of an RTO?
Can you elaborate on what you mean by what make a difference?
With the FERC numbers.
So these are numbers about how much electricity moves over the transmission system.
Right.
So it does not matter how a utility is set up. This is specific to the transmission system, these numbers.
Thank you. I have nothing further.
Thank you. Commissioner Howard.
Thank you, Mr. Chairman. Quick, Mr. Snyder states in his rebuttal testimony that solar is considered non-firm, cannot be depended on to reduce peak demand. Why do you believe that solar can be relied on to reduce peak demand?
So the numbers that I use in my calculation are the numbers that Duke uses in their own integrated resource plan on the contribution of solar during the winter, which is 5%. I believe that solar can reduce peak more than that. However, I have used Duke's own conservative numbers on how much solar can contribute during winter peaks to do my avoided transmission calculation. So this is not something I'm saying I believe. I'm using Duke's own numbers.
Therefore, you would use those numbers to make up peak demand during a long period of solar outages?
Can you restate what you're asking?
Yeah, with long periods of solar outages.
Like nighttime?
Long term. Solar outages, like 2 weeks or a month. You didn't have any solar energy. How would you handle that on your
in relation to the avoided costs. So these avoided costs are for the year. Right. They're not avoided costs for an individual point in time. And so obviously there's a potential that there could be a blackout or something for weeks at a time, but at the same time, there's also unplanned outages at any plant. So holding solar to a higher standard and saying that it needs to always be online and there can be no outages is not fair to solar in relation to other plants, because all plants have unplanned outages and maintenance, and you would not say that they have no firm capacity contribution just because a plant might go off, a nuclear plant or a natural gas plant might go offline. So I'd encourage you to hold all generators to the same standard.
I guess I was surprised to see your organization file something that's confidential. In a lot of respects, where do you get those numbers from? I would think any resource, the numbers you had on the confidential filing, you would use public records or something on the record, the numbers on the record. You mentioned FERC, but why is your exhibit, 3 or 4, confidential?
Because Duke has not published its plans on coal ash disposal. Part of what I'm encouraging in my testimony is more transparency on the costs of Duke's handling of coal ash. And this just speaks to that point. So there's no public information available on when Duke plans on building future coal ash landfills, the costs associated with those plans, when it plans to retire or when current landfills will be full. Because the information is not publicly available, the only way I could get it was through confidential discovery, and therefore the only way I could calculate the capital costs associated with coal ash disposal was in a confidential exhibit. So, as I said in my testimony, I encourage more transparency around the costs associated with coal ash handling and disposal by Duke.
In a residential customer using 1,000 kilowatts a month, you calculated how much your avoided cost for coal ash disposal would be?
I have not calculated the individual bill impacts.
Thank you very much. Thank you, Mr. Chairman.
Commissioners, any other questions? Ms. Bowen, any redirect? Thank you. Thank you, Ms. Glick. You may step down.
Thank you.
Okay, Mr. Nelson, will you call your panel?
Mr. Brazino, I'm going to start with, please state your full name and your occupation for the commission.
My name is Anthony Brazino, and I'm an auditor for the Office of Regulatory Staff.
And are you the same Anthony Brazino who pre-filed 14 pages of direct testimony in this case on August the 17th?
I am.
Do you have any changes or corrections to your pre-filed testimony?
Aside from the changes that come from the stipulation, no.
Did you also prepare 10 exhibits marked ADB 1 through ADB 10, which were filed along with your pre-filed direct testimony?
Technically, they are Audit Exhibit ADB 1 through Audit Exhibit ADB 10, but yes, I did.
And again, do you have any changes to those exhibits?
Only the changes that are brought about by the stipulation.
Mr. Chairman, ORS would offer the pre-filed direct testimony of Anthony Brazino into the record as if given orally from the stand.
Mr. Brazino's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. ORS would also ask that audit exhibits ADB 1 through ADB 10, which were filed along with Mr. Brazino's pre-filed direct testimony, be entered as the next hearing exhibit.
Okay, Mr. Brazino's audit exhibits ADB 1 through 10 will be entered as exhibit number 11.
Thank you, Mr. Chairman. Mr. Brazino, did you prepare a summary of your direct testimony?
I did.
Please present it to the commission.
Absolutely. Good afternoon, Mr. Chairman and members of the Commission. The purpose of my testimony is to present the results of ORS audit staff's examination of Duke Energy Carolina's books and records as they pertain to the company's operation of the fuel adjustment clause in the current filing. ORS audit staff examined and verified the monthly over and under recovery balances as recorded by the company for the actual 12-month review period that ended May 2018. The South Carolina Office of Regulatory Staff, South Carolina Energy Users Committee, and Duke Energy Carolinas have agreed to a stipulation in which the ORS withdraws its recommendation for the Oconee outage. The result of withdrawing the adjustment for the Oconee outage is that ORS's cumulative under-recovery of base fuel costs now agrees with the cumulative under-recovery for base fuel costs as shown in Witness McGee's Exhibit 2. This concludes my summary.
Mr. Schellinger, could you please state your name and occupation?
My name's Matthew Schellinger. I'm employed by the South Carolina Office of Regulatory Staff as a regulatory analyst.
And are you the same Matthew Schellinger who pre-filed 8 pages of direct testimony in this case on August 17th?
Yes, I am.
Have any changes, edits, or corrections to your pre-filed direct testimony?
No, with the exception that my testimony does not take into account the withdrawal of our recommendation of the outage at Oconee Unit 3.
Thank you, Mr. Schellinger. On that basis, though, Mr. Chairman, we would ask that the pre-filed direct testimony of Mr. Schellinger be read into the record as if given orally from the stand.
Mr. Schellinger's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Schellinger, do you also prepare or cause to be prepared 11 exhibits marked Exhibit MPS 1 through MPS 11, which were filed along with your pre-filed direct testimony?
Yes, I did.
Any changes, edits, or corrections to those exhibits?
No, with the exception that my exhibits 9, 10, and 11 do not reflect the impacts of the stipulation.
Notwithstanding that, Mr. Chairman, we would also ask that those exhibits of Mr. Schellinger's, which were filed with his pre-filed direct testimony on August 17th, be admitted as an exit hearing exhibit.
Mr. Schellinger's exhibits MPS 1 through 11 will be entered as exhibit number 12.
Thank you, Mr. Chairman. Schellinger, did you prepare a summary of your direct testimony?
Yes, I did.
Please present it for the Commission.
Good afternoon, Chairman and members of the Commission. I thank you for the opportunity to provide you with ORS's examination of the annual review of base rates for fuel costs for Duke Energy Carolinas. My testimony sets forth ORS's findings and recommendations resulting from our examination of DEC's fuel expenses and power plant operations used in the generation of electricity to meet its South Carolina retail customers' requirements. Subsequent to the filing of my direct testimony, a stipulation was reached between ORS, DEC, and the South Carolina energy users. Stipulation would increase the average monthly bill for a residential customer on rate RS using 1,000 kilowatt hours by approximately $3.16, or 2.78%. Stipulation is offered as a fair, reasonable, and full resolution of all issues of the signing parties in this proceeding. ORS believes that the stipulation is in the public interest of South Carolina and respectfully requests that the Commission approve the stipulation as presented. Thank you. This concludes my summary.
Ms. Johnson, finally you. Would you please state your name and occupation?
My name is Sarah Johnson. I'm the Deputy Director of Utility Services for the Office of Regulatory Staff.
And are you the same Sarah Johnson who pre-filed 7 pages of direct testimony in this case with the Commission on August 17th?
I am.
And if I asked you the same questions today, would your answers be the same?
They would.
Mr. Chairman, ORS asks that the pre-filed direct testimony of Sarah Johnson be entered in the record as if given orally.
Ms. Johnson's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Johnson, did you also file one exhibit along with your direct testimony marked Exhibit SWJ1?
I did.
Any changes, edits, or corrections to that exhibit?
No.
Mr. Chairman, ORS would offer the Exhibit SWJ1, which was filed along with Ms. Johnson's pre-filed direct testimony, as the next hearing exhibit.
Johnson's exhibit SWJ1 will be entered as exhibit number 13.
Mr. Chair, Ms. Johnson, did you prepare a summary of your testimony?
I did.
Could you please present it?
Good afternoon, Mr. Chairman and members of the Commission. The purpose of my testimony is to present ORS's review of Duke Energy Carolinas Distributed Energy Resource Program expenses during the review period of June 2017 to September 2019 and the proposed changes to Rider RNM. ORS proposes annual DERP charges of $10.73 for residential, $51.36 for commercial, and $1,200 for industrial customers. ORS finds that the company's DERP expenses were reasonably incurred and their calculations are in compliance with Act 236 and Commission orders. The company updated the value of distributed energy resources in accordance with Commission Order 2015-194. This concludes my summary.
Mr. Chairman, the panel of ORS witnesses is available for questions from counsel or the.
Thank you. Mr. Elliott. Ms. Bowen. Mr. Ellerby. Commissioners. Commissioner Williams.
Thank you, Mr. Chairman. This question is for Mr. Brazino. Did I say that right?
Brazino, yes.
Brazino? Okay, good. Thank you for being here today. On page 9 of your pre-filed direct testimony, you discussed an over-recovery adjustment of $66,306 made by the company to account for the differences between the actual and estimated economic purchase power costs and revisions for those purchases with costs exceeding DHEC's avoided variable costs. Did ORS review the company's invoices for purchase power and the company's avoided cost calculations in this case?
We did.
Okay. That's it, Mr. Chairman, for Mr. Brazino. I do have a question for Ms. Johnson. Good afternoon, Ms. Johnson. Good. On pages 3 and 4 of your pre-filed direct testimony, you discuss adjustments made to the company related to the DERPA incremental costs. The adjustments included an error detected when reconciling customer billing system information with final cost reports, an error discovered in the solar profile input data used to calculate NEM costs components, misallocation of certain costs, and adjustments to remove costs not associated with DERPA, or DERP, excuse me. Is ORS confident that all of the needed adjustments were made and that the company's DERPA incremented costs are correctly stated?
Yes.
Okay. Also, did ORS make any recommendations to the company that would help prevent errors and misallocations in future cases?
So we did in the DEP case, and that has come through to the DEC case. They have gone back and evaluated their reporting methodology for counts and kilowatt hours related to solar, and I believe that they are reporting those accurately.
Okay. Thank you. That's all I have, Mr. Chairman.
Thank you, Commissioners. Any other questions from Commissioners? Commissioner Irvin.
Ms. Johnson, how are you?
Good. How are you?
Good to have you with us today, the entire panel. Thank you for coming. In your assessment of the information that has been presented, is it your understanding or your experience that there's some generally accepted accounting principles that are applicable to the investor-owned utilities nationwide that might help the company in terms of assigning valuations to some of the items that we heard about earlier that were assigned a zero valuation? Give us a sense of what others are doing around the country in this regard, if you know.
I am not familiar with other methodologies. I have generally looked at what some other utilities are doing, but I have kept my review specific to what the utilities in South Carolina.
Sure. Well, for example, the company does business in North Carolina. Do you think it might be helpful to see what they are doing in North Carolina as they present this information to the North Carolina Public Service Commission?
I think it would be helpful to review what the North Carolina Commission does review. I know that they've recently passed some renewable resource legislation there, and we are monitoring that in some other dockets, and it could be beneficial if they have a methodology for valuing renewable resources.
And while that would not be necessarily binding on South Carolina ratepayers, it would at least provide some guidance, would it not?
It could.
Okay. Thank you.
Thank you, Commissioner Irvin. Commissioners, anything else? Mr. Nelson, any redirect? Okay, thank you. We had some question if we included Mr. Schellinger's rebuttal. Okay, so we're not gonna taken care of with stipulation. Okay, just wanted to make sure. Thank you, panel. You may step down. Thank you. Okay. I know. Let's see. We need to. I want to thank everyone for their participation in this. We need to go over the exhibit list or the list of what we've got.
Thank you, Mr. Chairman. I'm going to review the hearing exhibit list and also a few small housekeeping matters. So the list of exhibits that I have are as follows. Hearing exhibit number 1 is a stipulation. Hearing exhibit number 2 is Stephen Capp's pre-filed direct exhibits 1 through 3. That includes both a confidential and public version of his Exhibit 3. Our hearing exhibit number 3 is Eric Grant's pre-filed direct exhibits 1 and 2. Hearing exhibit 4 is Kenneth Church pre-filed direct hearing exhibits 1 and 2. Hearing exhibit 5 is Jason Martin's pre-filed direct exhibit number 1. Hearing exhibit 6 is Ms. McGee's pre-filed direct exhibits 1 through 14. Hearing exhibit 7 is Ms. McGee's pre-filed supplemental revised exhibits 1, 3, 9, and 11. Hearing exhibit 8 is Kevin O'Donnell's pre-filed surrebuttal exhibit labeled KW01. Hearing exhibit 9 is Debbie Glick's pre-filed direct exhibits DG1 through DG4, with DG4 being the public version. Hearing exhibit number 10 will be Debbie Glick's DG4 confidential version. Hearing exhibit 11 is Anthony Brazino's audit exhibit ADB1 through ADB10. Hearing exhibit number 12 is the pre-filed direct exhibits of Matthew Schellinger, MPS 1 through 11. And finally, our hearing exhibit number 13 is the pre-hearing direct exhibit of Sarah Johnson, SWJ1. I hope that matches what everybody else has. We have a few more things. One thing we need to discuss is proposed order dates. I think we had a brief discussion of this prior to the meeting, and Friday, September, the 21st, I think, seemed to be generally acceptable. Is that right? Okay. And finally, we did have a request from one party to present a brief in addition to a proposed order. Mr. Chairman.
Yeah, let's get you to the microphone so we can make sure we get you picked up everywhere.
Can you hear me now?
Yes, ma'am.
Thank you, Mr. Chairman. Acknowledging that it is more work on a tight timeline, I would respectfully request leave to file a post-hearing brief just on the issues that are in contention with this commission by the proposed order date of Friday. If there's no opposition to that.
No opposition to that, Mr. Chairman. If I'm instructed by our client, we'll do the same thing, but we're not guaranteeing that there'll be anything coming from us. But
okay.
Yeah, and of course, no objection to that as well.
Thank you.
Thank you.
I agreed and thanked everybody enough. Okay, if there's nothing else, this hearing is adjourned.